The United States trade policy landscape is going through a massive structural transition right now. Look, following the Supreme Court's February 20th ruling, which invalidated the administration's broadest emergency tariff tool under the International Emergency Economic Powers Act, the executive branch has been scrambling. They are actively searching for substitute authorities, and this whole situation really brings us to one central question for this explainer. Can the administration actually build a legally durable tariff regime using much narrower statutes? And on top of that, do these newly proposed tariffs over Canadian wildfire smoke represent a viable trade remedy, or are we looking at a political pressure tactic that expands policy way beyond its conventional legal limits? We're going to break all of this down. Here is our roadmap for today. We'll cover 6 main areas. 1. The post-SCOTUS tariff reality. 2. Rebuilding the tariff toolkit. 3. The looming July 24 deadline. 4. Unwinding the refund liability. 5. The wildfire smoke dispute. And 6. What to watch next.
All right, let's jump right into part 1, the post-SCOTUS tariff reality. Basically, life after the Learning Resources v. Trump decision.
So to understand this transition, we have to look at the timeline because it moved incredibly fast. It all started on February 20, 2026, when the Supreme Court handed down a 6-3 decision holding that the International Emergency Economic Powers Act, or IEEPA, does not actually grant the president the authority to impose tariffs. Chief Justice John Roberts made it clear, delegating a core congressional power like taxation requires really clear authorization, and IEEPA just didn't have it. Then, literally just 4 days later, on February 24th, the administration pivoted. A temporary global surcharge under a totally different law, Section 122, took effect. By March 4th, the Court of International Trade, the CIT, began mandating refunds for those invalidated tariffs. And now, we are staring down a strict statutory expiration for that temporary Section 122 surcharge on July 24th.
Now, I want to clear up a major misconception right off the bat because it's absolutely crucial. The Supreme Court did not eliminate all presidential tariff authority, not even close. While those sweeping global reciprocal tariffs and the targeted drug trafficking tariffs based on IEEPA were completely struck down, the broader statute-by-statute tariff architecture is totally intact. So tariffs based on Section 301 for unfair trade practices, Section 232 for national security, and standard anti-dumping and countervailing duties, those were completely unaffected by the ruling. The toolkit isn't empty, it's just different.
Which brings us to part 2, rebuilding the tariff toolkit. How exactly do you navigate Sections 122, 232, and 301? Without those broad, sweeping emergency powers of IEEPA, the administration is basically trying to reconstruct its tariff wall piece by piece, using alternative laws. But each of these tools has its own unique triggers and limitations. For instance, Section 122 allows for temporary tariffs to address balance of payments deficits, but it's legally capped at 15% and limited to a very strict 150 days. Then you have Section 232, which is based on national security threats. That gives the executive branch a lot of discretion, but the investigations can drag out for up to 360 days. Finally, there's Section 301. This one targets unfair foreign trade practices, but it requires extensive public comments, formal investigations, and hearings.
So, the reality on the ground for the executive branch is that these replacement tools are way narrower and significantly slower than the emergency powers they lost. The administration is now wading through strict statutory timelines, mandatory public comment periods, and the need for highly specific administrative justifications. Plus, every single action they take under these statutes is incredibly vulnerable to judicial review by the Court of International Trade. Just as an example, the U.S. Trade Representative recently proposed 10 to 12.5% tariffs on several economies based on forced labor investigations under Section 301. But right now, they are stuck in the proposal stage, subject to these exact procedural hurdles. It's a lot of friction, and this rigorous judicial review really highlights the unresolved uncertainty surrounding how durable this new regime actually is.
Let's move to part 3, the July 24 deadline. The clock is officially ticking on Section 122. All of that procedural friction we just talked about leads us directly to the most immediate pressure point testing this new tariff strategy. 150 days. That is the absolute maximum statutory limit of the Section 122 global surcharge that the administration implemented right after the Supreme Court ruling. What does that mean in practical terms? It means the authority for this temporary surcharge literally vanishes at 12:01 a.m. Eastern Daylight Time on July 24, 2026.
So what happens if Congress just doesn't extend it? Well,
If they failed to explicitly extend this authority, and if those alternative Section 301 or 232 tariffs remain bogged down in court battles or lengthy investigations, the administration is going to face a massive, prolonged policy gap. And this matters deeply to global supply chains. It would trigger a significant reduction in tariff collections and cause a sudden, incredibly unpredictable shift in cross-border costs for everyday businesses and consumers.
All right, Part 4, Unwinding the Refund Liability. Let's assess the financial fallout.
Now, if we look backward for a second, there is a massive financial complication triggered directly by that Supreme Court ruling that the government has to untangle. And it's really important that we separate estimated liability from actual money paid out. The Penn-Wharton budget model projects an estimated potential refund liability of up to $175 billion for those invalidated IEEPA tariffs. That's a staggering number. But remember, that is an estimate of total potential liability, not what is actually left the government's hands. According to Customs and Border Protection data, $71.1 billion has actually been dispersed to date through their electronic refund system. So $175 billion versus $71.1 billion, those are two very distinct metrics, and the final actual cost is going to depend heavily on how ongoing litigation plays out.
And a huge piece of that ongoing litigation revolves around what are called finally liquidated entries. Basically, think of these as customs entries that were finalized more than 90 days prior. They represent an estimated $11.4 to $30 billion in potential refunds. The Court of International Trade actually ordered universal refunds for these entries, but the Department of Justice is fighting it. They're actively appealing to the Court of Appeals for the Federal Circuit, arguing that Customs doesn't even have the legal authority to reliquidate these final entries unless individual importers file their own specific lawsuits. This single legal dispute could literally swing the final refund tally by tens of billions of dollars.
Moving on to Part 5, the wildfire smoke dispute. Is environmental harm suddenly a trade issue?
While the government is busy unwinding the past and managing these current statutes, a completely new frontier edge case has suddenly emerged. In mid-July 2026, thick smoke from severe Canadian wildfires drifted down into the U.S., heavily degrading air quality. In response to this, President Trump issued a statement alleging that the Canadian government engaged in willful negligence regarding their forest management. He declared, quote, "The cost of this pollution must of necessity be added to the tariffs Canada is currently paying." Now, we need to put our analytical hats on here. It is vital to note that this is a stated political claim and an intent. It does not mean Canada has been legally proven negligent in any court, nor does it mean a wildfire tariff has actually been implemented yet. In fact, independent scientists point to hot, dry conditions and broader climate trends as the primary drivers of the fires in these vast remote forests.
You really have to draw a hard line between the physical reality and the trade reality here. The physical reality, it's confirmed. Meteorological data from the Canadian Interagency Forest Fire Center showed 3,647 fires and 2.77 million hectares burned by mid-July. That's real. The trade reality, however, remains strictly theoretical at this point. Yes, there are political threats, and yes, there is a legislative proposal from Senator Bernie Moreno called the Canada Fire Act aimed at sanctioning officials. But to date, there is absolutely no formal, legally implemented tariff action regarding the wildfire smoke.
And this raises a fascinating structural question. Can environmental harm even legally fit into our existing trade statutes? Think about it. Section 232 requires a provable national security threat. Section 301 requires an unreasonable foreign trade act or policy that burdens U.S. commerce. Trying to apply these specific trade statutes to penalize a sovereign nation for a natural disaster completely bypasses established international dispute frameworks. It's a huge test. Is this a viable trade remedy, or is it just a political pressure tactic expanding way beyond conventional legal boundaries? It is highly uncertain if an action like that would ever survive judicial review. Furthermore, threatening tariffs against Canada carries massive diplomatic and economic risks, especially because North American supply chains are so deeply integrated. And adding fuel to this volatility is broader USMCA structural uncertainty. The July 1, 2026 joint review deadline for the trade pact actually passed with the U.S. declining to confirm a 16-year extension. Now, the agreement hasn't expired, but skipping that extension triggers a required process of annual joint reviews. This seriously heightens long-term uncertainty for any business relying on cross-border trade, and it directly threatens the stability of everyday things like energy prices and agricultural costs.
Finally, Part 6, What to Watch Next, the Institutional Triggers. With all this unresolved uncertainty spanning from invalidated emergency powers to new environmental threats, there are a few concrete institutional triggers that are going to dictate the outcome. First, keep a close eye on that July 24th deadline to see if Congress actually authorizes an extension of the Section 122 tariffs.
Second, watch for the appellate court's ruling on whether those finally liquidated entries will get automatic refunds. That's a multi-billion-dollar decision. Third, monitor the Federal Register for finalized USTR and Commerce Department filings to see which of these proposed tariffs actually survive the process to become active policy. And lastly, track whether the executive branch takes formal, administrative steps to legally initiate investigations into Canada over the wildfire smoke, moving it from a political threat to an actual legal reality.
So, let's wrap this up. The administration is undoubtedly trying to rebuild its tariff pressure, but the durability of this entire new regime depends 100% on strict statutory fit and rigorous judicial review. And that leaves us with one overarching, provocative question. Will U.S. policy successfully adapt to govern and penalize cross-border environmental disputes through tariffs, or will courts and Congress step in to restrict executive trade power strictly to its conventional economic purposes? The institutional developments over the next few months are going to give us that answer.